In this short video, we're going to look at an evaluation essay on involuntary manslaughter. Evaluation essays appear on exam 3. This question is, the current law on involuntary manslaughter attracts criticism and needs to be reformed urgently. Discuss the extent to which this statement is accurate. As usual, it's worth 25 marks and you would have 45 minutes to answer. This diagram is just included to act as a reminder of the different types of involuntary manslaughter. We have gross negligence manslaughter, reckless manslaughter, but as you can see there's some confusion about whether that really exists or really is it part of gross negligence manslaughter. And the other type is constructive act manslaughter. The other name for that we're familiar with is unlawful act manslaughter. So to answer this question, we need to explain the different types of involuntary manslaughter, and we need to evaluate each area, talking about any problems that exist. You get 10 marks for AO1, which is knowledge of your cases and rules, but you get 15 marks for your AO2, where you're evaluating whether the law is in need of reform or not, answering the question. So if we scroll down to my suggested answer, as usual, I've done the AO1 comments in black font and the AO2 comments in red font. Now my introduction is how I suggest that you answer a question evaluating involuntary. So I've started off by saying, in its report in 1996, the Law Commission identified two major problems with involuntary manslaughter. Firstly, it covers a very wide range of conduct, and there's a lot of confusion between the different types of involuntary manslaughter. And secondly, these blurred lines lead to problems in sentencing and in labelling defendants. And that's something we've seen with the law on murder as well. The Law Commission are quite concerned about whether we are accurately labelling the culpability of defendants who have killed. So I've listed then the different types of involuntary manslaughter: unlawful act manslaughter, which I'm going to abbreviate to UAM, gross negligence manslaughter, GNM, and reckless manslaughter. And I'm going to tackle them in that order. So starting with unlawful act manslaughter, there are 4 elements that we need to prove. The defendant must do an unlawful act, the act must be dangerous on an objective level, the act must cause death, and the defendant must have the mens rea for the original unlawful act. So they don't have to have mens rea to kill, obviously, because that would be murder. They just need mens rea for the original unlawful act that they've done. So on this basis, this type of manslaughter is sometimes known as constructive manslaughter. And that's what we can see there in the diagram. And the reason it's known as constructive manslaughter is that because guilt or liability for a death is constructed, or it's built up, from the defendant's original crime. So, for example, I'm assaulting someone by waving a knife at them, and the person falls and lands on the knife, and I kill them. That would be unlawful act manslaughter, because my unlawful act is the assault, waving the knife, and we build up my liability through these steps. Now, the fact we build it up when I didn't foresee death, I only intended to assault somebody, the fact that we build it up in this way means that it's unattractive in principle, because a defendant can be liable for a death that he didn't foresee. And of course, that seems quite harsh. So this is the main criticism of unlawful act manslaughter, in that it's very harsh to the defendant. So I'm now going to go through each of these 4 elements, and I'm going to evaluate as I go. So the first requirement is that there has to be unlawful act. Omissions aren't enough, the criminal act must be complete. You can see that I've cited my cases there in brackets. And I've evaluated straight away by pointing out that the offence is harsh because the unlawful act might be a fairly low-level assault, like the example I just gave you waving the knife, and yet the defendant can be liable for manslaughter, and of course that carries a discretionary life sentence. Now, because that is harsh, the second rule for unlawful act manslaughter is that the unlawful act should be dangerous on an objective level. That comes from Larkin. It doesn't need to be aimed at the victim. So in Mitchell, we saw the defendant didn't actually physically touch the little old lady who fell over. And it can even be aimed at property. So in Goodfellow, the issue was fire of a building. So straight away, I've evaluated here. I've said that Larkin illustrates the harshness of the offence, because in Larkin, he only meant to scare the victim. So arguably, he should only be liable for assault, because he doesn't really have the mens rea for death. There's also been a lot of confusion. I should put this in red. Sorry, let me change that there. There's also been much confusion about when a burglary can be said to be dangerous. Because often if someone breaks into a house, it's not going to be dangerous. But the cases of Dawson, Watson, Bristol, Dunn and DeLay have all talked about the fact that a burglary can be dangerous, but fine distinctions have been drawn with them. So in Dawson, emotional disturbance was not enough. In Watson, they said that it was dangerous because the man in question, the victim, was frail, and that would have been obvious. And in Bristol, Dunn and DeLay, they said that convictions for burglary that resulted in a death were okay because a reasonable person would foresee the risk of some harm resulting from the burglary. So these cases show that the law is developing in an inconsistent and unclear way. There aren't particularly clear rules about when something's going to be seen as dangerous or not. And of course, that's a problem. We can't advise our clients properly. Third requirement is that the unlawful act must cause death. And this has been a real problem. We've mentioned this in other topics, but this has been a real problem where the defendant has supplied the victim with illegal drugs. So in cases where the defendant supplies an illegal drug, if they inject the victim and the victim dies, then that's unlawful act manslaughter. They've done an unlawful act administering the drug. It's dangerous, it's caused death, and they had the mens rea for administering the unlawful drug. But complications have crept in where the victim has injected themselves. So we've got cases here, Cato, Kennedy, Dolby, Diaz, Rogers, all of them talking about the law on this area. And the fact there are so many cases illustrates how complicated, confusing this area is. Kennedy overruled Rogers. So again, whenever you've got a court overruling another decision, that's illustrating that the law is not clear-cut, mistakes have been made. So the position now is that if the defendant injects the victim, this is unlawful act manslaughter, but if the victim self-injects, that'll break the chain of causation, so it wouldn't be unlawful act manslaughter. But a further complication occurred in Evans, where the defendant supplied their sister with drugs. The sister self-injected, which broke the chain, but then the defendant failed to summon medical assistance, and it was held that that could be gross negligence manslaughter. So, depending on who injects, will affect whether it's unlawful act or gross negligence. Injection by the defendant, unlawful act. Self-injection but failing to summon care, gross negligence manslaughter. And because this is a fairly recent case, Evans was 2009, it suggests that the law on manslaughter and drugs is still under development. It's developed in a very ad hoc way. We can't really predict where it's going to go in the future. So clearly that's an issue here. Final requirement for unlawful act manslaughter is that they intended the initial unlawful act. They don't have to realise it was dangerous or unlawful or even foresee a risk of harm. and therefore it's easy to satisfy the mens rea, very harsh on the defendant. I'm now going on to consider gross negligence manslaughter. So there are three elements here: duty, breach and gross, and they come from Adamaco. Sorry, I should have highlighted that. There we go. And as I've done before, I'm going to go through the elements, explaining and evaluating as I go. So duty of care then is the first element for gross negligence. We use the normal civil principles here, so neighbour principle from Donoghue and Stevenson, and I've given just a few case examples of where a duty has been held to exist. Main criticism with this duty of care issue is that gross negligence manslaughter is mixing up civil law negligence and criminal law. And that has been criticised. The Law Commission say that we should avoid civil language in criminal law because it's confusing and it's best avoided. So we can criticise all of gross negligence manslaughter on the grounds that it is too similar to tort, and tort should be very different to criminal. Second requirement is it's been breached, causing death. We've touched already on a problem there with causing death and drugs. And of course, we've already said that with Evans, you could have gross negligence manslaughter if they fail to summon help. Where are we now? Sorry, there we are. And the negligence that's occurred must be gross. In the case of Bateman, the test was given, and the test is the negligence of the accused must go beyond a mere matter of compensation between subjects and show such disregard for the life and safety of others to amount to a crime against the state and conduct deserving of punishment. So this test can be heavily criticised, and it has been by the Law Commission. It is circular. It's a circular test because the jury is entitled to convict the defendant of a crime if they believe the conduct was criminal. And this leaves a question of law to be decided by the jury, who don't give reasons for their decisions. Remember, usually the jury are master of the facts. The judge is master of the law. But here we're asking the jury to answer a question of law. Is it gross enough to be criminal? And of course, depending on the jury, you're going to get inconsistent decisions as well. Next issue is about reckless manslaughter. Some people are arguing about whether it exists at all. There's only one known case on it, which is Lidar. And in Lidar, he was liable because the probability of serious harm or death was present, and that risk was assessed and taken by the defendant. Many argue that this is just gross negligence manslaughter by another name, and the fact that we've got this reckless manslaughter floating about adds more unnecessary confusion to involuntary manslaughter. Why not just get rid of this and just call that gross negligence manslaughter? I've then mentioned here that we've got the Corporate Manslaughter and Corporate Homicide Act. Means that the law on gross negligence manslaughter is less necessary than it used to be. And as part of my conclusion, I've mentioned the 2006 report by the Law Commission, and we've talked about this particular reform suggested by them before when we've looked at murder, when we've looked at voluntary manslaughter. But the Law Commission have suggested changing the law of homicide so that we have 3 tiers: first degree murder, second degree murder, and manslaughter. And seemingly, if that was adopted, it would address many of the problems that exist with involuntary manslaughter and this confusion about the differences between the two. And as usual, at the end there, I've got the mark bands. So you want to be up here for your AO1, maximum 10 marks, up here for your AO2, maximum 15 marks. And if you followed this plan, and you can see I've got a nice balance of red and black throughout, that suggests I'm going to get a nice balance of marks across the 2 bands. Okay.